ratifying the international convention, it is not that state is under the obligation to enact the law. Just at the same time, international obligation is created and same thing is discussed by Indian Constitution through Article 51 that if India has taken part in any kind of international treaty or convention, anything which is discussed in that convention, India is having the authority to pass a law for the decision made by that international convention. Just and honorable relations between nations. It provides the neighborlyhood principle of international law, whereby each state must behave in a manner which is not defective to the neighbor state. If state wants to test its defense weapon, it should test that kind of weapon in the area within the state and in such a manner that reversal effect should not be made to the neighbor state. It is called the principle of neighborliness. It is prescribed straightway in Article 51 Clause B. Clause C speaks about the protection of the international law and treaty obligations on the people of the organization as one another. It is the duty of each state to live in peaceful manner with each other. The D provision of Article 51 speaks encourage settlement of international disputes by arbitration. This is having no connection with our environmental law topic. It is the duty of each and every member of UNO to settle their dispute by amicable means, by peaceful means. This is what the meaning of clause D. As Article 51 puts international obligation, that it is the international obligation on state to enact law for any convention, covenant, resolved, passed by the international organization, international entity, international agencies. At the same time, by Article 253, this same obligation is also created directly to the Parliament, as Parliament has power to make any law for the whole or any part of the territory of India for implementing any treaty, agreement or convention with any other country or countries, or any decision made at any international conference, association or other body. To explain this particular provision, I would like to state the provision of 3 lists, as Parliament can enact any subject or any act relating to subjects enumerated in Union list. Parliament is not having authority to enact a law relating to the matters enumerated in state list. But if the subject of state list is discussed in any international treaty, agreement or convention with other country or state, though the subject falls within state list, Parliament can enact law for the enforcement of the decision taken in or at this treaty, agreement or convention. Article 51 speaks the enactment authority. It is the obligation of state to provide the ABCDE rights, policies to its citizen, whereas Article 253 exclusively speaks about the power of Parliament to enact any legislation relating to the entries of state list. This is the meaning of Article 253. As per the Union list, entry number 13 and 14 also puts international obligation on state to enact law. As these entries are contained under Union list, state means the Parliament. It is the duty of a Parliament to enact laws relating to entry number 13, which says participation in international conferences, associations and other bodies and implementing of decisions made thereat. If the Union is going to take part in these kind of international activities, decision taken in that conference or association or other bodies, it is the duty of the Parliament to enact the law for application of that decision as per entry number 13. As per entry number 14, entering into treaties and agreements with foreign countries and implementing of treaties, agreements and conventions with foreign countries. If the Union is going to enter as the signatory or ratifying or becoming the member of treaties or agreement with foreign countries, or by way of implementing that treaty or agreement in India, Indian Parliament can pass the law. For this purpose, we have enacted Air Pollution Control Act, we have enacted Environmental Pollution Control Act 1986. These two acts are specifically passed by Indian Parliament for application of these entry number 13 as well as entry number 14. This international obligation also speaks about the duty of a state to apply any decision taken at international conference, international body or international agreement. So dear friend, Article 51, Article 253 and entries number 13 and 14 of Indian Constitution provides international obligation on Union or on state for passing any law relating to the protection of environment. If obligation is only put on state, but there is no duty given to its citizens, you cannot play willingly this kind of game of Indian politics. If state is only having the duties, if only either way citizens are having only duty to be followed, it is not considered as the successful enactment of the law of the land. As obligation is made on state, in the same manner obligation is also made on citizens by Article 51A. Dear friend, due to the 42nd Amendment 1976, this particular Article 51A was inserted by inserting Chapter 4 capital A in the Constitution. From 72, when Stockholm Conference was held, to 1976, This period was considered as the very important period for emerge of the environmental law. On one hand, India participated in the Magna Carta provision of human environment, and due to which the obligation was created by that conference to frame a law for India to apply that Magna Carta in India, as well as the interpretation made by Supreme Court relating to Article 21 by various judgments rendered by the Supreme Court of India. It was needed to amend the Constitution, and 42nd Amendment was taken place in the year of 1976, whereby this particular Article 51 capital A was inserted, which prescribes fundamental duties of the citizen of India. These fundamental duties, amongst which Clause G specifically provides for the obligation, the duty to protect environment, the burden of proof is on the shoulder of the citizen. Article 51, capital A, Clause G provides that it shall be the duty of every citizen of India to protect and improve the natural environment, including forests, lakes, rivers, and the wildlife of the state, and to have compassion for living creatures. Dear friend, I would like to emphasize on three words of this article: citizen. The second one is improve and protect. These are the three words which I would like to discuss. Before independence, we were the subject of our nation. Subject do not have feelings. Subject do not have honor. As we are independent, as we are politically independent by enacting the constitution for ourselves, it is mentioned in Article 51, citizen. We are the citizens of the state. We are not at all the subject matter of a state. It is the obligation on the citizen to protect the environment. Not only to protect, but to improve the environment. We should stop polluting environment, but we should cure the polluted environment also. This is the duty as enumerated under Article 51 capital A G. We should protect or improve lake, forests, rivers, and we should have compassion for living creatures. Compassion means mercy. Compassion means feelings to take care. We should take care of other living creatures. The citizen's fundamental duty is also prescribed by the Universal Declaration of Human Rights under Article 29, Clause 1. Everyone has duties to the community in which alone the free and full development of his personality is possible. This is reflected in Article 51, capital A G. While discussing this particular constitutional provision in the case of L.K. Kulwal versus State of Rajasthan, the High Court of Rajasthan discussed the validity of the Rajasthan Municipal Act 1959, whereas it is the primary duty of municipal authority to clean public street, places and all all spaces not being private property which are open to the public for their enjoyment. The municipal corporation was not cleaning the streets or open places of the city of Jaipur, which was resulted into the environment of the diseased environment. So as Jaipur corporation was not fulfilling this primary duty, it was challenged in this particular case, whereby it was declared by the High Court that Article 51 is the right of citizen, as it creates the right in favor of citizens to move the court to see that the state performs its duties faithfully. Article 51 capital A is not the directive principle of state policy, so it is the constitutional right of a citizen to enjoy the environment. So that is the right of every citizen to make pressure on state to clean the public places or spaces open for the enjoyment of public. So this was challenged and it was decided by High Court that it is the duty of a state to render its services for the pollution control and for improvement of environment. Yet friends, we have to discuss the another point for citizens' fundamental duty, whereby if state is there for providing rights to its citizens should follow the duties enumerated in Article 51. So here I conclude with these constitutional aspects of environment too. It brings right of the citizen as well as it is the duty of citizen. In the same way, it is the obligation on state, national and international to provide the pollution free environment. I hope you enjoy this lecture and I am able to clear the concept of this constitutional aspect of environmental law. Thank you friends.